All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the statewide training initiative with Florida Legal Services. We're excited to have you join us today for ethical strategies for expanding access, managing conflicts, and legal aid practice. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you registered, you're going to receive a copy of this recording in an email from Zoom within about 24 hours. If you don't see that email, feel free to let me know. I'll make sure you have access to it. We will also be posting it on YouTube. So if you didn't register or you want to make sure you share it with somebody else who didn't have a chance to register, they're going to be able to find it in our channel. So make sure to bookmark our channel and subscribe so you can find this training and other webinars that may be of interest. This training was approved by the Florida Bar for one general CLE credit and one ethics credits. I will announce the CLE code towards the end of the webinar. If for whatever reason you miss out on it, I will drop it into the chat, but it will also go out via email and it will also be in the YouTube description as well. Closed captions are enabled for anybody who needs them, so if you're having any issues with accessibility, do not hesitate to reach out to me. This training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. So if you're not familiar with PILS, this is a great opportunity to take a look at the site, particularly if you're a private attorney that wants to work with some of the legal aid attorney community. So feel free to click on the link that I'll drop into the chat to learn more about the Public Interest Law section. And questions. I know this is a topic that we all have a lot of questions on. So one thing that I will ask is that if you do have questions, please use the Q&A feature. We will try to address the questions at the end to make sure we cover all the content. If for whatever reason we don't have time to answer all the questions, feel free to email me and I'll make sure that our speaker has access to those questions and hopefully we can provide any answers. So with all of that said, it's my pleasure to introduce our speaker today, Juan Carlos Arias. Juan Carlos is a former U.S. Army JAG officer who served as a military prosecutor and special assistant U.S. attorney before transitioning to civilian practice. After prosecuting cases with the state attorney's office in Broward County, he became bar counsel with the Florida Bar, where he investigated and prosecuted attorney discipline matters and twice argued before the Supreme Court of Florida. He now represents attorneys and other licensed professionals statewide and frequently lectures on lawyer regulation and legal ethics. So without further ado, it's my pleasure to pass it over to Juan Carlos. Juan Carlos, the floor is yours.
Thank you, Jorge, for the invite, and also to the Florida Legal Services and co-sponsors for this initiative. I know that Jorge does dozens of training sessions throughout the year, and we are absolutely blessed in Florida to have your organizations working towards educating and making our communities better. And nothing better to make our communities better than providing pro bono service through legal aid. And that's what we're going to talk about today. Ethical strategies for expanding access, managing conflicts in legal aid practice is a very common area of concern for pro bono attorneys, that they want to make sure they do not get in trouble, especially because of the conditions on how these potential clients come to different events and are screened in manners that are a little bit unusual from the private practice. So all legit concerns, and we're going to attack those concerns today. In order to understand how to better practice through legal aid as a pro bono attorney, you need to obviously refresh on the issues of the rules on conflicts and confidentiality. And that's why we're going to spend some considerable amount of time rehashing some of the foundations of conflict of interest and confidentiality, because in order to be able to understand how the pro bono world should work, we need to understand how what rules apply. And of course, all of these rules on confidentiality, conflict of interest, duties to prospective clients are the same for every attorney. So whether or not you are in private practice or in government or doing pro bono work, these all apply. We're also going to talk about short-term limited legal services programs and Rule 4-0.6, because there is a unique treatment of pro bono attorneys under the rule, and because we're trying to expand, service to our communities, especially those that are the franchise. We want to make sure that we perhaps apply the rules in ways that make sense to promote the practice of pro bono by attorneys out there in the state of Florida. Advisory Opinion 92-1 is right on point on guiding us as to how the legal service offices can help parties, and it could be parties on both sides of a litigation. So we'll talk about that opinion that is right on point, and then Jorge is going to jump in and he's going to talk to us about some specific areas on the back end on how to, in the office side, handle these potential conflicts of interest, and he will take on that final topic. Just to make it simple for everyone, these rules right here are all interrelated in one way or another. 4-1.6 confidentiality of info, 4-1.7 conflict of interest with current clients, 4-1.18 duties to prospective clients, 4-1.9 conflict of interest former clients, and the general rule. We're going to hit these rules before we go to the general rule. I know it makes no sense, but it will make sense to you after we dissect this. Again, they're all interrelated. Rule 4-1.6, confidentiality of information. What is the fuss, all the fuss about, conflict of interest? Well, in essence, it's all about confidentiality, okay? As you all know, the law of evidence and the Florida bar rules create a very strong shield to protect confidentiality of information, that basic principle of the attorney-client relationship. Clients need to feel comfortable and need to open up to us as attorneys, and without confidentiality and the protections afforded by these sources of rules and guidance, our bedrock of attorney-client privilege and that relationship would be basically dissolved. So when you apply both the law of evidence and the Florida bar rules to information, that's how you decide what to disclose and how to disclose it and how to protect the disclosures. 4-1.7, conflict of interest, current clients. Let's talk about current clients. Give us the premise of how you start a conflict of interest analysis, and in particular for current clients. So A tells us under 4-1.7 that except as provided in subsection B, and that's informed consent, we'll talk about that later on, a lawyer shall not represent a client if, shall not. 1, the representation of one client will be directly adverse to another client. Sometimes it's not very obvious, but there has to be a direct adversity. And 2, there is a substantial risk. So now we're looking ahead that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest. So one is in the moment adverse, the other one is in the future, that there could be a limit on giving you 100% of you giving a client 100% defense, 100% representation, because there are other things in the game. And I like to use the example of the car accident, where two people from the same car come to you, okay? And that, one was the driver, one is the passenger. They come to you because you're the best attorney in their heads, and they're like, we want you. And you do a check of the facts, and it seems that everybody is aligned. It wasn't the driver. The driver stopped at the stop sign, and then after stopping, start moving forward, and somebody runs the other stop sign and T-bones the car, and now you have the driver and the passenger of the same car. So is there a direct adversity at this point? Doesn't seem like. Is there substantial risks that down the line the stories may change? There is. Some people take their chances. They give conflict of interest waivers, beautiful, and then a year from now, the passenger now hates the driver. Both are your clients, and suddenly the passenger needs to talk to you and comes and says, "You know what? He was actually on the phone. He wasn't looking, or he didn't stop at the stop sign." Now you have an adversity. Now this person make a claim against that driver, and now you have a problem in your hands. So again, some basic principles that I'm refreshing your recollection on. Always read the comments to the rules, and here there is a comment on A, both 1 and 2, both the adversity and in the future terms. And loyalty to a client is also impaired when a lawyer cannot consider, recommend, or carry out an appropriate course of action, like in the example I gave you, because you have the driver and now the passenger just changed the story. Technically, you would have to tell the passenger, listen, now with this change of story, you may have an action against the driver. So you cannot be impaired by this duty to that passenger now, and put out options on one case because that makes you not give 100% for the passenger anymore. Because you want to preserve the other client, and you can't be adverse to the client. So it's messy. It's a messy situation. If the conflict, in effect, forecloses alternatives, you got to be very careful, because you can't let, other options materially interfere. So these are, problem areas down the road that you need to understand when you undertake these cases. So A was the adversity and the foreseeable issues. B is informed consent. And B is important because it says, notwithstanding the existence of a conflict of interest under subsection A lawyer may represent a client if. Now you're venturing into making assessments here, but 1, the lawyer reasonably believes, remember what reasonable means. Reasonable means that other people may reasonably disagree with you. So you remember that from law school. Every time you have reasonable, be careful. The lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. In the example I gave you about the car accident, originally, you may have had a reasonable belief that, hey, everything is going to work out. But when the facts change on you a year later, may not be reasonable anymore. So very careful. 2, the representation is not prohibited by law. 3rd, the representation does not involve the assertion of a position adverse to the other client. That would never fly. Okay, so that would be a no-no. And each affected client gives informed consent confirmed in writing. So A is important for you to understand, and B may allow you under these particular four options here, not options, but 4 considerations. C, explanation to clients. When you have multiple clients in a single matter, you need to make sure that you explain the implications of common representation and the risks. Like in the case of the accident, hey, you're both saying you're aligned right now with your stories. The facts, as I understand them, are aligned. but understand that down the line, if there's an issue, I may have to get out of both cases, you know. So it's very important that you guys are, honest and et cetera, et cetera, et cetera. D has to do with blood adoption and marriage. And a lawyer related by blood, adoption, or marriage to another lawyer, okay, as parent, child, sibling, or spouse, must not represent a client in a representation adverse to a person who the lawyer knows is represented by the other lawyer family member. We don't want the dad on one side of a case, the dad attorney, and the daughter attorney representing the other side. It's just not good practice, and obviously, if you can uphold all these four considerations under B. It says, except with the client's informed consent, confirming writing or clearly stated on the record at a hearing. I don't know about that. I don't have the stomach for that, but there is an exception. Walk in at your own risk on this one. E, representation of insureds. That's just to make sure that everybody understands who is paying and where the loyalties are. Because again, conflict of interest, confidentiality is about loyalty at the end of the day. So you can read that on your own. Also on the comment of 4-1.1, 4-1.7, sorry, a lawyer may be paid by another source. That's not relevant right now because it's pro bono, but as you know, it's just, you got to make sure that they understand who your loyalty goes to, and it goes to the client, not to the person paying. When somebody charges a conflict, obviously the primary responsibility of clear the air is going to be the person undertaking the representation. So it's on you to explain the issues, and everybody who's going to look at you. Family relationship, I already explained it. That if there's a disqualification because of this, it doesn't extend to all the members of the firm because it's obviously something familial. So it could generally be cured by you not participating when it's just the and then you have to create some walls, but it can be done. It doesn't disqualify the entire firm as under other rules, and we'll talk about one of them that disqualifies everybody in the firm. Remember, I'm just covering and refreshing recollections. This is hours of training just for conflict of interest in I call it the real world out there. We're just laying the foundation to talk about conflict of interest for pro bono, and you gotta refresh your recollection on this stuff. 4-1.9, conflict of interest, former client. So we were talking about active current clients. Now we talk about former clients. And a lawyer who has formerly represented a client in a matter must not later, afterwards, A, represent another person in the same or substantially the same, substantially related matter. So you got to make sure that you're not switching, okay, sides in something that it seems to be related. B, use information that you obtained when you were representing the former client against or to the disadvantage of that former client. That happens. Some people now have a new client that is going to go after the former client, and you may have information that you may have obtained that may be crucial or may be detrimental, and you got to be careful with that and reveal information about that past representation that would violate the rules. Because remember, confidentiality continues after representation of a client ends. Rule 4-1.10, conflict of interest, now the general rule. So we talked about current client, about confidentiality, current client, former client, and now we go to the representation by the lawyer and effect on others, which is the actual general rule. So why or when do I get involved in this type of cases? It has to do usually because somebody's disqualifying somebody. That's when I get the call, Juan, we need an expert on this. This is what's happening. So usually this is what comes up. And when you are hiring, and this is a bit technical, but law firms hire attorneys, they hire paralegals. When you are hiring, you need to consider, especially in some areas like the insurance industry, they still, attorneys from first party and then third, and they switch and they had cases assigned. Normally, that's really messy. And I've been involved in several of these situations with insurance companies. But when hiring, you need to consider the ethics rules, the enhanced litigation scrutiny to determine disqualification. I point at the enhanced litigation scrutiny because we're going to point later on this. The way these cases are litigated and treated by courts is not necessarily how the ethics rules go. So be aware of that. You need to know where you're sitting and what kind of case law applies to your district, because it is a little bit messy. That could be hours of instruction on what district and what jurisdiction does what, because they apply different tests and they have their own ways of figuring out whether disqualification is proper or not. So I'm alerting you. That's all I'm doing here. That where you are sitting and where that case is sitting makes a big difference, that jurisdiction. So the general rule of conflict of interest under 4-1.10 is that imputed disqualification of all lawyers in a firm. While a lawyer is associated with a firm, none of them may knowingly represent a client when any one of them practicing alone will be prohibited under the conflict of interest rules, period. Everybody's disqualified. That is the general rule. One disqualified means everybody in the firm. B, former clients of newly associate attorney. When a new attorney comes to the firm, okay, and becomes associated with a firm, the firm may not knowingly represent a person in the same or substantially related matter in which that lawyer or a firm in which that lawyer was associated had previously represented a client whose interests are materially adverse. So now you get that attorney that comes in was associated with a firm that had an adverse interest against a client in the new firm. That is a problem, because if he's the same or substantially the same, then you have an adversity, and you will be you will have an issue of conflict of interest. So very careful. Representing interests adverse to clients of formerly associated attorneys. So now the attorney leaves your firm, and when that attorney has terminated an association with a firm, the firm is not prohibited from thereafter representing a person with interests materially adverse to those of a client represented by the former associate lawyer, unless the matter is the same. So you can undertake a different matter, even though is going against that attorney who left, who had a former client. So again, all these are factually specific analysis. I'm just pointing out some of the intricacies for you all as part of this. Waiver of conflict. Conflicts here may be waived by the affected client, okay? Again, it has to do with how specific you explain this, make sure it's in writing. And again, very careful. Usually the stuff that I get involved in with disqualification is in litigation. And of course, clients are normally the former client, or the affected client is normally the one bringing it up through their attorney. So good luck getting a waiver on that. Is not really realistic, but it could happen. The comment of the rule on the general rule talks about the functionality analysis on ethics considerations regarding disqualification, and the essence of this analysis has to do with preserving the confidentiality and avoiding positions adverse to clients. So that's really what's behind the functional analysis. An application of this analysis depends on the particular facts and circumstances. It's a case-by-case basis. What is the information? How was it obtained? How does it affect in this matter? Is it a related matter? All these things come to play. Um, the rule, the actual rule on this ethics analysis makes a distinction between attorneys and non-attorneys. And says that non-attorneys must be also screened because they bring confidential info with them. Those paralegals, those legal assistants that were assigned. So when they go to a firm that is now on the opposite end, it does create a problem. So you need to be, aware of that. And furthermore, relating to functional analysis, the rule operates to disqualify the firm only when the lawyer involved has actual knowledge of relevant info protected under the confidentiality and the prior rules we discussed. So that is the bedrock of that analysis. And then there's ethics opinion 86-5 and the opinion starts on the top of the opinion. If you read it, says, and I quote, while opinion 86-5 permits screening of non-lawyer employees, you see, they are actually distinguishing lawyer from non-lawyer to avoid conflict of interest. It does not purport to address the possibility of disqualification in litigation. Why? Because the courts have applied their own standards. We are all over the place in Florida. So even this opinion says that even if you follow the shielding and you try to get everything right, there is a possibility of disqualification. It's acknowledged by that opinion. And I don't want to spend a lot of time on the different cases out there, but as I said before, in litigation, when people start pointing fingers at each other, hey, that attorney should be disqualified, that firm should be disqualified. Usually, you have different tests and considerations to determine disqualification in the different districts. So where you sit, where that jurisdiction is going to be very important. Some courts have made little distinction between non-lawyers and attorneys because they look at the info itself and how it was obtained and how to protect that confidentiality. So I guide you or I provide you some case law that has looked at this, and in this particular one, the Heller Lacko and Walter Heller, he says that to preserve public trust, it is subject to these agents of lawyers to the same disability lawyers have. So they have put lawyers and non-lawyers in the same level when it comes to the analysis. And that's just one case out there to show you how there may be a distinction in the bar rule, but in practice, in litigation, some courts basically look at the confidentiality rule regardless of who is holding the info or who has the info. In general, when prima facie shown of a potential disqualification for violation of these rules, the burden shifts to the hiring firm to show a greater weight, and of course, no actual knowledge. So it's very factually specific, this analysis. Prospective clients. Now we get closer to our area here on pro bono through legal services, because prospective clients are those clients that walk in, and you see it in pro bono, you see it in our practices. So the rule is 4-1.18, duties to prospective clients. Whether or not they hire you, whether or not you are retained, these duties apply. A, to a prospective client, a person who consults with a lawyer about the possibility of forming a client-lawyer relationship with respect to a matter is a prospective client, okay? And deserves protections. B, confidentiality of information. Even when no client-lawyer relationship ensues, there is never a retainer, there's never a retention. A lawyer who has learned information from a prospective client may not use or reveal that information in general terms, with respect to information of that former client. So I think we're all clear on that it is confidential. C, subsequent representation. Even when no client-lawyer relationship um, um, occurs, a lawyer subject to the subdivision B may not represent a client with interests materially adverse to those of the prospective client. This happens and has occurred in family law cases and I've been involved in some of these on the bar defense side, where the wife comes first, spills the beans, does not hire the attorney, then the husband follows, and then the husband hires the firm. So I've seen that happen. So you can't represent in the same or substantially related matters. So you got to have those conflict checks in place, obviously, because you don't want to be realizing, oh wait, that was the husband of the lady that I spent 3 hours with, 2 months ago. Very important that you have the check and balances in your practice on that. The permissible representation. When the lawyer has received disqualifying information as defined in subsection C, representation is permissible if both affected clients, have given informed consent. Again, very dangerous because they may flip on you down the line if you start pressing. You had them, oh, don't worry about it. The wife tells you in that case that I told you, go ahead, take his case. This is going to be so friendly. It's going to be an easy, we get along well, and then they don't. And then they start pointing fingers. And now, the wife is going to use, this representation. Oh, but I gave her that info. You don't want to be in the middle of that mess. So very careful. But technically, black letter here says that you could get that informed consent waivers. And of course, you take reasonable measures to avoid exposure to more disqualifying information. So danger zone. These options on D are danger zones, as you can imagine. The litigations in all areas are emotionally charged usually, and that in the future you'll probably have some issues down the line. It's foreseeable, so be careful. Advisory Opinion 92-1. Very important because talks about how to assign pro bono attorneys to opposing parties. So we are now red hot on pro bono legal aid stuff here. Legal aid may not represent opposing parties. No, no. However, there is an ethical way for legal aid offices to assist both parties. And this is some guidance given by that opinion. One, it is permissible for the intake interview by separate private pro bono attorneys. So you can assign, for purposes of the intake, different pro bono attorneys that are private. You're not going to have the legal aid attorneys doing this, and that way there's no inherent conflict in any way. These people are screening independently without any shifting of loyalties, and that's permissible in the intake by separate private pro bono attorneys. And two, it is permissible for legal aid to take one of the cases and refer the other out to a private pro bono attorney, or refer both cases out to private attorneys. You see? So now legal aid is not holding confidential info and that or have an adverse position, by sending either one case out or sending both out. So these are permissible ways of avoiding a conflict of interest in the representation and still fulfilling the mission of helping these individuals that at the time obviously are adverse. But it's recommended. This is very important. If you're going to follow recommendation 1 or 2, it is important that 1, informed consent to waive confidentiality exists prior to the intake interview. Everybody needs to be put on notice. All these people in that line waiting to be seen that Saturday morning, that they understand that they're waiving for purposes of the intake interview. So make sure that there is a paper trail of that communication and that is informed. The word informed consent means that. It's not just to give them the form. You need to make sure that they have understood. Listen, we may, assign somebody. You're waiving for purposes of us pointing you on the right direction for this purpose. You are consenting to waive confidentiality. And two, retainer agreement, when is formalized, this representation provides that legal aid may choose to handle the client's matter itself or may refer the matter to a private pro bono attorney. So you see, it's all clear. So when that determination is made of whether or not legal aid is going to keep it or one of the cases or send both out, that the client was informed that that was a decision to be made down the road, and then there are no issues. So these are the recommendations. And again, this comes from an opinion. So this is black letter law for us when it comes to legal aid. So obviously, some things to consider. Now, practical strategies to serve more clients ethically and using limited scope models and protocols. And here we move to Jorge, who has an inside knowledge of all of these things. Go ahead, Jorge.
All right, thanks, Juan Carlos. So I wanted to share some resources with the group. I know one of the terms that you may have heard when it comes to limited scope models is unbundled services. It's a really popular term in the materials, and you will be able to click on this link for one of my go-tos is the ABA limited scope representation site resources. They have a handbook, which is pretty long. It's hundreds of pages, but in the materials, I tried to kind of highlight where you probably need to go. So I'm going to try to drop it in the chat, even though the index will tell you to go to specific pages. Here we go. I don't think the link will work in the chat, but I will drop this other link just in case. So this is just an example of one of those resources where whenever you have time, as Juan Carlos mentioned, there's a lot of content here that you could go through for hours and hours. So I would say start off with the ABA handbook. I will try to, the link will be in the materials. You'll be able to access it. They actually provide samples of limited scope representation resources. They have some samples that I probably wouldn't use, some samples that are really simple or really good. Some of them are really long. I know it's not always practical in the legal aid world when we're doing like whether it's a phone intake to try to get some of these 6-page documents signed, but it does provide you a lot of ideas for your organization to use. Another resource when it comes to limited scope services that is highly valuable for the legal aid community is the Self-Represented Litigant Network. They actually have a listserv. I believe they now have it under Access to Justice Network. So in the materials, I will include a link that takes you directly to their website. I usually don't participate in those conversations anymore, but I do follow that listserv, and they always have great ideas, whether it's how do we use outreach technology and different ways to better assist the clients that we serve. And on a more technical note that it's really specific to the legal aid community is Legal Server. So if you're on this call, you're probably legal aid and you're probably familiar with Legal Server. Legal Server, if you're not familiar with Legal Server, that's the case management system that I would say all legal aids use, at least all the legal aids in Florida use Legal Server. And with Legal Server, there are ways to restrict access to cases and even links for some cases. In the materials, I included a long list of different ways that you can do this, but I know when Carlos mentioned familial, when there's like a family relationship, there's a way for me to block, for your Legal Server admin, to block certain people from accessing certain cases. You can put case alerts, and with Legal Server, there's a lot of other ways to be creative and restrict access to cases. The most typical one would be a pro bono user. So let's say Juan Carlos, he wants to volunteer for legal aid. We create a user profile for him as a pro bono user. He won't be able to see any of our client files. He will only be able to see the cases that we specifically assigned to him. And that's kind of a way, when you look at that ethical opinion 92-1, that's kind of a way to control and use technology to be able to wall off people and protect confidential information. So that's really easy example for pro bono users. If you're with legal aid, you will notice under users, you will see a list of pro bono attorneys, but there's other ways to restrict access to cases. You can block people users individually. You can block people by grants that are being used for the case. You can block cases by office, by program. So there's like endless ways that you could use this technology. So in the materials, these are links that will take you to the help site. Now, uh, disclaimer, usually the admins are the ones your legal server admin is the one that has the ability to do this. So reach out to your admin. Maybe they're familiar with the process. It's doable. Maybe your organization already has a process in place on how to handle uh, uh, these situations. I know back in the day in prior organizations, I've had like, okay, so and so, can you block so and so from the case? And we would just go ahead and document it that way. Legal server actually allows you, if I'm blocking Juan Carlos from a case, I can say like, here's why I'm blocking Juan Carlos, and it's documented in there. So it's just kind of one of those ways to use technology to restrict access. And with legal server, with the pro bono users, it kind of goes specifically to the conflict rules that the Florida bar has when it comes to limited scope agreements. It's a great way not to impute conflicts to others. So just kind of want to put it out there because there's endless resources on this. And I know with conflicts, we could just go on and on and on and come up with a lot of different scenarios. Maybe people have different answers when it comes to, those terms that Juan Carlos mentioned, substantially related matters, right? There's case law, there's examples. One area that I definitely would advise for you to go through would be those ethical opinions. And I have detailed notes in the materials on how to do this. If you go to the Florida Bar Ethics Opinions site, they have a lot of categories. You can actually, there's one tab where it's by subjects, and they have like a bunch of subjects in there. There's one for conflicts of interest. And when you open up that tab, you're going to find hundreds of advisory opinions. What I like about these opinions is sometimes they're on point. They will provide examples that you could use that apply to your practice. Maybe the examples that they provide are not necessarily for the types of cases that we handle, but they do provide guidance. I like looking at what's considered substantially related. If you see an advisory opinion where it says like in this fact pattern where you had one spouse and another spouse, we don't consider this substantially related, you could use that to make a decision on not a conflict, right? Because if you're legal aid, part of I guess the main topic with this is expanding services and maximizing access to services. I wish we were able to help everybody that comes to our legal aid organizations. Sometimes, there's a conflict. So one of my goals with this webinar is to start off this conversation and hopefully do more follow-up webinars on best practices and hear from the other legal aid organizations. And what are your practices? What do you do? For example, Bob Smith. I'm going to use a really common name, Bob Smith. He calls your legal aid and you document on legal server, Bob Smith called, and Bob Smith gives you some income or an asset information, and he doesn't qualify for services. But when you look at the duties of prospective clients that Juan Carlos mentioned earlier, that is confidential information that still needs to be protected. You have a duty to Bob. So 10 years from now, somebody calls and they say, I have a problem against Bob Smith. And when you look at the file, you're like, is that the same Bob Smith? Sometimes there's no ways to determine whether this is the right person, and you have to kind of go deep into that conflict analysis. And what I'm hoping to do is come up with ideas and organize more webinars and more meetings where we can have this discussion and hear from others. And how do you handle these circumstances? I would always recommend in that Bob Smith example, how do I do my intake where I control the conversation, limit the confidential information, and try to get identifying information. Like, Bob, what's your middle name? Don't give me your middle initial, give me your full middle name, because maybe Bob has a very unique middle name that helps me distinguish this Bob from the next Bob. Getting the date of birth, that could help identifying the information. And if you're familiar with legal server, uh, adding the date of birth really narrows down those potential matches, and it makes it a lot easier for you to go through that conflict analysis. So those are just some pointers. This is the type of topic that I could just go on and on and on. And I would definitely welcome ideas from the legal aid community, whether you have fact scenarios that you would like to discuss. Like if you would like to send these fact scenarios, and we could set up recurring meetings where, okay, let's discuss these. And do you think it's a conflict? What's the analysis? How do you approach it? Because sometimes too we want to be cautious with conflicts. We just don't want to say yes to everybody and just try to. We can't just disregard the or hide the confidential information. If I don't look at it, it doesn't matter. So we still have a duty to those prospective clients and former clients, but at the same time, we want to be able to serve as many people as possible. So those are my not my 2 cents, Juan Carlos, probably more like my $2 worth of
That's like a
information and
hundred
pointers.
bucks,
But
like $100. But I wanted to highlight something you said because I am not in the inside of legal aid, obviously, and the most interesting point that I wasn't aware of was that the programs that are being used allow that capacity to wall these clients. I didn't know practically how that was done by legal aid. So when that client one is maintained and the other one sent out, or both sent out, you have ways to protect the confidentiality, and I think that brings a lot of good reassurance to all of those who want to engage in pro bono and they didn't know, that it's not something manual. There is a technology behind that, and that's obviously very good to know. And you pointed that out. And I want to have a disclosure. You're not looking seeing double, by the way. It's Jorge and I seem to resemble each other, but we're not twins. I was not invited because I know him. It's just we look alike. That's it. Good looking people from Puerto Rico. That's all I have to
yeah,
say.
there you go. All right. So if anybody has questions, with ethics, with ethical topics, I know sometimes people would rather ask questions if we're not being recorded. So one thing that I'm going to do is I'm going to drop the CLE information first. I'm going to drop some links. The CLE code for this webinar is 25175110N. So I'm going to drop it in the chat as well. It's going to go out via email. You're going to see it in the YouTube description. I'm going to drop a link to the materials, but because what I want to do is kind of wrap up the official recorded version here and stop recording. If you have questions, you can either use the chat, the Q&A. You can even raise your hand and it can bring you off mute if you're more comfortable doing it. So let's go ahead. I have the code in here. Let me make sure I drop the materials as well. And in the materials, there's one particular document. I'm going to drop it here in the chat as well, where I put a lot of links in there. I have the instructions on how to find these ethical opinions that I was mentioning, and I didn't mention this part, but case law. If you have Westlaw, look up at case law. You might be able to find a lot of great examples there where it talks about disqualifying an attorney based on a potential conflict. Maybe you can find a case that is on point when it comes to, family law. So with that said, I'm officially wrapping up here for the recording. Juan Carlos, thank you a lot for doing this webinar. I've been at prior trainings that you've led, and when this topic came up, I was like, yeah, I need to get Juan Carlos to do this, and you graciously said yes immediately. So thank you so much for leading this
Thank you.
webinar. And final words for the recording, Juan Carlos?
Yes, I want to thank all of you. I know you are overpaid and underworked, but I want to thank you on behalf of everybody in Florida. You guys do a great job, and you will have a little opening in heaven down the line. Okay, thank you all. Be safe.
All right, so I'm going to stop the recording and I will